Thank you for joining us today as we talk about some of the new regulations governing information exchange, and in particular, how providers are going to be affected by these new regulations. Our team of speakers today includes Joellen Sakowitz-Klein, Daniel Graver, and me, Kelly Cleary. We're attorneys in Aiken Gump's healthcare and life sciences practice. We're based here in DC, and we have had the pleasure of working together for many years now. I'm going to go ahead and dive right into the substance, but if you want to learn more about us, you can check out our bios on the Aiken Gump website. In our hour together, we are going to talk about the policy landscape, how we got to where we are today, some of the new certification standards for electronic health records, the new information blocking prohibition and its penalties, the CMS interoperability and patient access rule, and we'll close out with some practical tips and takeaways. As most of you will recall, back in 2009, the federal government invested roughly $35 billion in taxpayer dollars to digitize paper-based medical record systems. 10 years later, a lot of our health information is stored in electronic health records, but that information isn't always portable or even accessible. So Congress was particularly displeased with what they saw as slow progress towards interoperable health information systems. And also with some of the behaviors that they were seeing in the marketplace in terms of the data that some of the holders of the technology and holders of the data were engaging in to further what they believe was their own competitive interests. So in 2016, Congress passed the 21st Century Cures Act, which, among other things, took aim at the interoperability problem, and it also created federal penalties for information blocking practices. And how did providers get caught up in all of this? Well, the government had collected some evidence that providers were engaging in information blocking as a means to control referrals and, as they put it, enhance market dominance. According to the Office of the National Coordinator for Health IT, providers were inappropriately citing the HIPAA privacy rule as a reason for denying the exchange of healthcare information, when in fact, according to ONC, HIPAA would have allowed for the exchange. So in other words, the concern was that providers were using HIPAA as a pretext for restricting access to data. And we'll talk more later on about that intersection between HIPAA and information blocking. At 30,000 feet, the regulatory regime that's been built and is still being built at HHS around information exchange and information blocking policy is complex. There are 4 separate agencies within HHS that have overlapping jurisdiction in this space, and that includes the Office of the National Coordinator for Health IT, sometimes called ONC, CMS, the Centers for Medicare and Medicaid Services, the HHS Office of the Inspector General, the OIG, and the HHS Office for Civil Rights, OCR, which enforces the HIPAA privacy, security, and breach notification rules. And then there is a door number 5, behind which is a yet to be proposed rule that will tell us which agency in HHS is going to be in charge of imposing what Congress said would be appropriate disincentives on providers that information block, and also what those disincentives will be. So there are still some moving pieces and some gaps in these policies that are going to be filled in the coming months and years. And Daniel, I will kick it over to you.
Thank you, Kelly, and hello, everyone, and welcome. This information blocking rule applies to health IT developers that will seek certification through ONC's Health IT Certification Program, including health systems that have self-developed a complete EHR or individual health IT modules. Failure to maintain compliance with these new conditions could result in decertification, which in turn could result in cuts to hospital and physician reimbursement, the kind of commercial carrot and stick that creates a significant incentive to obtain and maintain certification here. While this rule imposes new obligations and new enforcement risks, the rule also provides significant new opportunities for innovation, efficiency, and patient outcome improvements, leveraging the newly available data across the healthcare space. But brass tacks, the real question is, what are you going to expect from your new EHR? So you will have access to more and better patient data with integration across care settings, enhanced functionality that will provide new opportunities to leverage third-party tech, and this is a chance to enhance everything from decision support for providers to medication adherence for patients. So there are definitely going to be benefits from this new information blocking rule. You'll be able to seamlessly populate your patient's medical history across the provider landscape. Patients will be happier and healthier. They'll be able to leverage this new technology for immunization tracking across providers or medication adherence solutions for patients. We also could expect to see fewer medical errors, as this will coordinate records across allergies and prescriptions to avoid drug interactions. The new EHR will support full data export to support transition to a new IT vendor if you are unhappy with yours. It also will create some new obligations to upgrade health IT. You're going to have to add new data fields to your electronic medical records, some new functionality, and there will be broader information disclosure obligations. I'm going to run through a few of the key definitions and concepts for this rule. Electronic health information, EHI, this is essentially, eventually, and subject to change, what data is going to be subject to the information blocking rule. This ended up being much more narrowly defined than had first been proposed in the proposed rule. It conforms to HIPAA's definition of EPHI that would be included in a designated record set, so electronic protected health information. It also applies to all entities, whether or not they are subject to HIPAA. So it will apply to, for example, application developers who wouldn't otherwise be subject to HIPAA. This is all a little bit subject to change, as the full scope of the EHI obligations don't come into effect until May of 2022, which is a long way away. Definition is the United States Core Data for Interoperability Standard, USCDI. This is what must be included in the new EHR records. It's a standardized set of health data classes with things like health concerns and your care team members. USCDI is proprietary to the United States government. It is the floor that defines the minimum data that must be available for exchange and stored in an EHR. This is the evolution of meaningful use, which evolved into the common clinical data sets, and that has since evolved into USCDI under this rule. It is primarily updated to require you to include clinical notes and source metadata, so you know where different records in the electronic medical record came from. Another important addition here is HL7 Fast Healthcare Interoperability Resources, or FHIR. So Health Level 7 is a nonprofit standard setting organization, and this is a set of descriptions of how data must be shared. HL7 FHIR sets both the standards for the API, which I'll talk about in a minute, for exchanging health records, and is a method for describing data formats and data elements. Moving on to a summary of new conditions for certification. This new rule sets out a number of new conditions for health IT developers. One of them is information blocking. Developers can't information block, which Kelly will discuss in more detail momentarily. It requires the developer to provide assurances to HHS that they won't undertake anything that constitutes information blocking or otherwise interfere with the user's ability to access or use certified capabilities. The last part is important because the otherwise interfere is intentionally broader than just an obligation not to engage in information blocking. The assurances include, amongst other things, that the health IT conforms to the full scope of the certification criteria, and that the health IT conforms to single patient and patient population export capabilities, again, to allow an individual patient to access their records, but also to allow you as a provider to collect all of your patient data and transition it to another IT vendor. The communications condition is a pretty fun one. Essentially, there's been a lot of complaints around non-disparagement and gag clauses in health IT contracts. So such clauses are no longer permitted. Developers can no longer limit or restrict users' communications regarding usability of their health information technology, interoperability, security, the user's experience with the technology, or business practices of the developer. This is an interesting point. If you're frustrated with your EHR, you may have a gag clause that would prevent you from expressing that publicly. You not only will be able to now, developers cannot enforce existing non-disparagement clauses in existing contracts and can't add them to new ones. The only limitation on the communications front is a narrow, reasonable restriction to protect IP. There are also new real-world testing obligations to make sure that the IT modules continue to perform as advertised outside of the controlled development environment. There's API requirements that the developer must publish their APIs to allow EHI to be accessed, exchanged, and used without special effort. And there are attestations, finally, to wrap all this up. The CARES Act requires health IT developers as a condition and maintenance of certification requirement to provide to the Secretary an attestation of all of these conditions of certification. Essentially, this is the hook for ONC enforcement. APIs are thrown about a lot, and I think that it's helpful to demonstrate it with an example. An API is a software interface that allows for interactions between various software packages and databases. So, for example, a health IT app developer may design a medication adherence phone app that allows an individual patient to track all of their prescriptions from all of their different providers and alert them when it's time to take their next dose of each medicine. The standardized API interface under this rule will allow the developer, using really just the minimum data necessary, to request on behalf of the individual just their medication list from each of their providers and aggregate all of that onto the patient's phone in real time. The API is the software bridge that lets you identify, reach out, and grab and share data in between databases and software packages. And this new capability is going to open up a lot of doors across the board for new opportunities for the health IT. Now I'm going to hand it over to Joellen to discuss data blocking.
Thanks, Daniel, for providing those highlights of Part 170. Let's keep chugging along through the CFR and shift our focus to Part 171, the information blocking rule. Through the information blocking rule, and consistent with the CARES Act, ONC sought to address concerns that some individuals and entities were engaging in practices that unreasonably limited the availability and use of EHI for authorized and permitted purposes. They wanted to liberate trapped data. Yet they didn't want to paint with such a broad brush that regulation might undermine efforts that were important, like efforts to improve healthcare quality and efficiency, accelerate research and innovation, protect privacy, and provide greater value and choice to healthcare consumers. The end result is a regulatory regime that broadly applies to a wide range of actors and essentially creates a rebuttable presumption that certain data practices that do not fit within defined public policy exceptions are against the law. Liberate the data with all due care. Generally speaking, information blocking is a practice by a covered actor, a healthcare provider, certain health IT developers, a health information network, or a health information exchange that, except as required by law or deemed by regulation to be a reasonable and necessary activity, is likely to interfere with access, exchange, or use of electronic health information. Given the very fundamental nature of this definition, let's pause for a moment and read it together and then unpack it some. So, what is information blocking? Information blocking means a practice that, except as required by law or covered by an exception, is likely to interfere with access, exchange, or use of electronic health information and, if conducted by a health information technology developer, a health information network, or health information exchange, such developer, network, or exchange knows or should know that such practice is likely to interfere with access, exchange, or use of EHI, or if conducted by a healthcare provider, such provider knows that such practice is unreasonable and is likely to interfere with the access, exchange, or use of EHI. Now, we could devote an entire hour-long presentation and then some to unpacking this definition, but let's just kind of poke at it. For starters, let's focus on the very important phrase to interfere with and unpack that. To interfere with means, under the regulations, to prevent, materially discourage, or otherwise inhibit access, exchange, or use for permissible purposes. This would include denial of access or exchange of EHI, but it may also include other more subtle forms of interference, like denial of access to a base URL necessary to enable access, exchange, or use of EHI, unreasonably slowing or delaying access, exchange, or use of EHI, or charging a fee for accessing EHI that doesn't involve any additional work on behalf of the entity. Now, we have to unpack this even more because permissible purpose also is a defined term under the rule. A permissible purpose is a purpose for which a person is authorized, permitted, or required to access, exchange, or use electronic health information under applicable law. Now, it's going to be very interesting to see in the future and as our presentation rolls along how this regulatory regime evolves in practice alongside HIPAA, where many uses and disclosures of PHI are permitted but not required. Let's hone in now on what types of individuals and entities will be within scope and need to contend with this information blocking rule. Well, where HIPAA has its covered entities, information blocking has its actors. The information blocking rule extends to healthcare providers, health IT developers of certified health IT, and health information networks and health information exchanges. It's important to determine whether and how you're in scope. ONC has noted that the information blocking exceptions are applicable to all actors, but pay attention because in some instances, conditions within an exception may apply to a particular type of actor. For those of you who are hoping to make a quick and easy slide from HIPAA to information blocking, I hate to disappoint, but even where terms overlap, they often have a different meaning. ONC affirmatively declined to adopt the HIPAA definition of healthcare provider, turning instead to the Public Health Service Act. Kelly, do you want to talk now a bit about health IT developers of certified health IT?
Of course. Thanks, Joellen. So health IT developers are defined as those that, one, develop health IT, meaning those that are legally responsible for the certification status of the IT, as well as those that offer the IT. So someone that makes the certified IT available for purchase or license. And as Joellen pointed out in the information blocking definition, it varies based on what type of actor you are. And especially around intent, the intent that's required to trigger the prohibition and a violation. If you are a developer or an exchange or a network, you're going to be judged based on your actual or your constructive knowledge, whether you knew or should have known that your behavior was likely to restrict use, exchange, or access of EHI. If you are a provider, only actual knowledge will trigger a violation. And what kind of actor you are will also dictate how you might get penalized for information blocking. So what happens if you are both a provider and a developer? Well, ONC's regulation says that if you are a provider that self-develops health IT for your own use, meaning you're not offering it commercially to unrelated entities for their own use, you're going to be regulated as a provider, not a developer, for purposes of information blocking. The third type of covered actor, as Joellen mentioned, is the Health Information Network / Health Information Exchange. Congress identified HINs and HIEs as distinct entities, but when it came time for ONC to define what those terms meant, they decided that they meant largely the same thing. So at a high level, the terms describe individuals or entities that enable the exchange of information among various unaffiliated individuals or entities for treatment, payment, and healthcare operations purposes. And they're the ones that control the policies around who can access it, what you can take out of it. And they're the ones that can dictate whether and how information within their networks or exchanges can be used, accessed, or exchanged. So if you remember nothing else about this definition, remember that it is a functional definition, meaning that just because some arrangement is not labeled a health information exchange or a health information network, it could be functioning as one, and therefore it could be regulated as one. Back to you, Joellen.
Thanks, Kelly. Let's take a moment and talk about information blocking as it intersects with the HIPAA privacy rule. In some regards, the intersection of HIPAA and information blocking yields, in the irreverent words of Marvin Martian, an earth-shattering kaboom. The impact of the information blocking rule will resonate through provider policies and procedures as well as through their agreements. In the preamble, ONC spelled out that the information blocking provision may have the effect of requiring actors to provide access, exchange, or use of EHI in situations where the HIPAA rules would not require access of similar information. This is because the HIPAA privacy rule permits but does not require covered entities to disclose EPHI in most circumstances. Indeed, ONC continued to drive home the point that the information blocking provision requires that an actor provide access to, exchange, or use of EHI unless they're prohibited from doing so under an existing law or are covered by one of the exceptions. It feels in some ways like HIPAA pulled kind of inside out. ONC summed it all up quite nicely with this statement from the preamble. We do not require the disclosure of EHI in any way that would not already be permitted under the HIPAA privacy rule or other federal or state law. However, if an actor is permitted to provide access, exchange, or use of EHI under the HIPAA privacy rule or any other law, then the information blocking provision would require that the actor provide that access, exchange, or use of EHI, so long as the actor is not prohibited from doing so, assuming that no exception is available to the actor. Providers will need to review carefully both state and federal laws permitting disclosure of information that is EHI, as these provisions have taken on very new importance under the information blocking rule. Indeed, before information blocking, there were a host of permitted disclosures under HIPAA, especially in the 164.512 public policy exceptions, for example. And in these situations, if a covered entity met the conditions for the exception, the information could be disclosed, or they could say no. Simultaneously complying with the information blocking rule and HIPAA will require a growth mindset for providers. Two ethos need to coexist. We need to expand the HIPAA mindset of you can't disclose unless you can, to embrace the information blocking mindset of you must disclose unless you can't. Now let's turn to the information blocking exceptions, which are critically important. As we've discussed, information blocking targets practices that are likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. To avoid unintended consequences given its wide reach, ONC identified 8 information blocking exceptions to ensure reasonable and necessary activities wouldn't be mischaracterized as information blocking. ONC divided these 8 exceptions into 2 categories. The first category includes denial exceptions, and the second focuses on process-related exceptions. I'll give a brief overview of all of these exceptions, and then Daniel and I will drill down on a few to give you a sense for how they play out in real time. Importantly, practices may still pass muster under the information blocking rule, even if they do not meet all of the conditions of an exception. Instead, such practices will be evaluated on a case-by-case basis to determine whether information blocking has occurred. The facts and circumstances will be considered, and intent will be evaluated, consistent with the information blocking rule. Now, let's begin with the first category. To start off, we have the preventing harm exception. Under this exception, it won't be information blocking if an actor engages in practices that are reasonable and necessary to prevent harm to a patient or another person, as long as certain conditions are met. Next, we have the privacy exception. This exception allows some breathing room under the information blocking rule to allow actors to deny requests to access, exchange, or use EHI in order to protect an individual's privacy, provided that certain conditions are met. Turning to the other side of the coin, we also have a security exception, which similarly provides some latitude in order to protect the security of EHI. Actors can also take advantage of an infeasibility exception, where if certain conditions are met, requests to access, exchange, or use EHI may also be denied. The last exception in this category is the health IT performance exception. Under this exception, it won't be information blocking for an actor to take reasonable and necessary measures to make health IT temporarily unavailable or to degrade the health IT's performance for the benefit of the overall performance of the health IT, provided certain conditions are met. Now let's turn to the second category of exceptions. First, we have the content and manner exception, which Daniel will describe shortly. Then we have the fees exception, which essentially provides that it won't be information blocking for an actor to charge fees, including fees that result in a reasonable profit margin for accessing, exchanging, or using EHI, again, provided certain conditions are met. And last, we have the licensing exception, which Daniel will also cover. Let's take a deep breath and start with the privacy exception. Acknowledging that some restrictions, while not required by law, may be both reasonable and necessary for the privacy and security of individuals' EHI, ONCS developed the privacy exception. To meet this exception, an actor's privacy protective practice must satisfy at least one of four sub-exceptions. First, if an actor is required by a state or federal law to satisfy a precondition, like a patient consent or authorization requirement, before providing access, exchange, or use of EHI, the actor may choose not to provide access, exchange, or use of the EHI if the precondition has not been satisfied, and you have to pay attention to the certain circumstances. Second, if an actor is a health IT developer of certified health IT that isn't subject to the HIPAA privacy rule, they may choose to interfere with the access, exchange, or use of EHI for a privacy protective purpose if certain conditions are met. The third sub-exception is tied to the HIPAA access regulations and basically permits denial of a request if the denial was allowed under HIPAA. The general idea is that if a provider could say no to an access request under HIPAA, they should be able to say no under the information blocking rule too. The fourth and final sub-exception allows an actor to choose not to provide access, exchange, or use of an individual's EHI if doing so would fulfill the wishes of the individual, which are important and need to be respected here. And again, though, you have to pay attention. There are always going to be certain conditions that have to be met. One point I'd really like to drive home is that the devil's in the details under all of these exceptions, especially true in the twists and turns of the privacy exception. And also, pay close attention to how terms are defined. Just because you saw something defined previously in another regulatory context doesn't mean it carries the same definition here. For example, in applying these sub-exceptions, providers really should take note that the term individual is defined very broadly for purposes of this particular exception and is a much farther-reaching term than the HIPAA term individual, with which many may be familiar. Given all the nuance here, providers seeking to take advantage of this exception will really need to pay strict attention to the details and maintain appropriate documentation. Next up, let's take a closer look at the fees exception. Okay, ONC has made it abundantly clear that they don't like it when actors engage in practices that artificially increase the cost and expense of accessing, exchanging, and using EHI, and that these types of practices could implicate the information blocking rule. They included a list of rent-seeking and opportunistic behaviors in the proposed rule that survives, a very handy reference of what not to do. The purpose of the fees exception is to enable actors to charge fees related to the development of technologies and provision of services that enhance interoperability while not protecting rent-seeking, opportunistic fees, and exclusionary practices that interfere with access, exchange, and use of EHI. Rather than bore into the details here, I thought this exception provided an excellent case in point for what is meant by the important phrase, provided certain conditions are met. ONC has emphasized in the rule that to satisfy an exception, an actor must meet all applicable requirements and conditions of the exception at all relevant times. To satisfy this particular exception, the fees exception, as you can see, an actor would need to check a bunch of boxes, and then they're fine, as long as other boxes aren't checked, and of course, unless an exception applies. In satisfying the fees exception, and most of the exceptions, the devil is going to be in the details and in the documentation. I now turn it over to Daniel, who's going to walk us through the content and manner exception.
We've already seen significant interest from a number of clients around the content and manner exception and how it modifies their information blocking obligations for information requests. Essentially, the content condition is what you must provide, and the manner condition is how you must provide it. The content condition states that through May of 2022, you are only legally obligated to share data elements from the US CDI dataset. So if you receive a request for information that is broader than what is included in the US CDI dataset, you are not obligated to provide it. However, after May 2nd of 2022, providers must share all EHI, which is all of the US CDI data plus any other information that would be part of the patient's designated record set. The manner condition is how you must share that data. This is different from the infeasibility exception. Under the manner condition, you have to find a reasonable alternative, and this is a waterfall. The manner condition provides that if the requester asks you to share data using your certified health IT, you must. If you cannot, then you can instead provide it using another national standard requested by the requester. If you cannot do that, the fallback position to find a reasonable alternative is then to instead provide that information in some alternative machine-readable format agreed upon with the requester. The licensing exception, much like the fees exception, you may license your interoperable hardware, software, and IP, but only under prescribed, let's call them generous commercial terms, broadly laid out here with a lot of exceptions. And now I think that we'll move on to some of the juicier bits of this presentation: enforcement and civil monetary penalties.
As I mentioned at the outset, there are multiple regulators in this space, and some of them are holding different enforcement hammers. Congress, when it enacted the Cures Act, gave the Office of the Inspector General, the OIG, primary authority to investigate claims of information blocking. And the Secretary was given authority to impose penalties of up to $1 million per violation on developers and HIEs and HINs found to have engaged in the practice. The Secretary has delegated that authority to the OIG, so the OIG is going to be doing both the investigation and the imposition of the penalties. But again, the monetary penalties are reserved for the developers and the health information exchanges and health information networks. There are other agencies inside and outside of HHS that are also going to have jurisdiction over the actors and the conduct at issue. We have CMS, we have ONC, OCR, and also the FTC. OIG issued a proposed rule back in April explaining its enforcement approach. In it, the OIG said it's going to closely coordinate with other agencies within HHS, such as ONC and OCR, as well as other federal agencies, such as the Department of Justice and the FTC, to ensure that information blocking penalties aren't going to duplicate other penalties that might otherwise apply. OIG is also planning to refer some complaints directly to OCR when the complaint involves a potential HIPAA violation. OIG is likely going to refer those to OCR and let OCR deal with those. As we've discussed, the penalty that might be applied for an information blocking violation is going to depend on the actor. So for developers, again, they are going to be subject to civil monetary penalties of up to $1 million per violation. Those are going to be imposed by the OIG. ONC also has authority to take action against developers that engage in information blocking, and they can do that by through termination of certification of their products. And then, of course, to the extent that a developer is subject to HIPAA, such as through a business associate agreement, there are going to be potential HIPAA penalties and settlements, which would be levied by OCR. For health information networks and health information exchanges, they're also subject to the CMPs of up to $1 million per violation. And like developers, if they're subject to HIPAA, they're going to be subject to penalties by OCR. Then we get to providers. As I said earlier, the civil monetary penalty authority for information blocking does not extend to providers. What Congress did there was it said that if an OIG investigation discovers that a provider has engaged in information blocking, OIG is to refer the provider to the appropriate agency who will apply the appropriate disincentives. And those have yet to be defined through rulemaking. Congress really punted on the provider enforcement piece, and that ball is still sailing through the air. And we don't know when it's going to land or where it will land, but that's something to watch out for. And of course, providers are likely subject to HIPAA penalties by OCR, and Medicare providers, hospitals, and clinicians that are subject to the quality payment program are they're also going to have some implications, some reimbursement implications if CMS believes that they've engaged in information blocking. And CMS has also said it intends to publicly post the names of information blockers on its various public information websites. Enforcement is going to be largely driven by complaints. The OIG has not to date established any formal complaint process. However, it has been meeting with stakeholders over the last several years, and they've staffed up. They have staff that are ready to investigate and take enforcement action. ONC has put together a portal and which invites aggrieved parties to report instances of information blocking. And it also directs these parties to contact OCR directly if there is a potential HIPAA violation. And I'll note that OCR has been actively pursuing HIPAA right of access violations and has continued to push ahead with enforcement activities, notwithstanding the current pandemic. And some of those enforcement actions have been covered in recent weeks. Because information blocking enforcement is going to be complaint driven, and because the OIG's resources are not infinite, the OIG is going to have to pick and choose which complaints it does want to investigate. So it is said that it's really going to focus on conduct that is potentially going to cause patient harm, that is getting in the way of providers' ability to care for the patients, any conduct that lasted a very long period of time, conduct, of course, that is causing financial loss to other parties. And the more egregious the behavior, the more intentional the behavior is, OIG is likely to focus its energy on that conduct as well. And when does enforcement start? The timelines are still in a state of flux. For ONC, the regulations are, the information blocking regulations are effective. However, ONC did push back the compliance dates. Currently, there is a regulation, an interim final rule pending at the Office of Management and Budget, meaning it's under kind of the final stage of government review and it is likely to be released soon, that according to its title is going to further extend or further push out the compliance dates for some of the new obligations in the ONC final rule. The OIG, they have issued a proposed rule. They have not yet finalized that rule, and they do not intend to start taking enforcement action until they have, in fact, finalized that rule. And certainly they cannot take enforcement action on an information blocking violation before the date on which that ONC has told providers they have to comply with it. And then, as we discussed, HHS has to undertake further notice and comment to determine who is the appropriate agency to apply appropriate disincentives. OCR, unlike those other three components I just mentioned, they have existing authorities to penalize conduct that involves patient right of access violations, among other practices that may run afoul of HIPAA. Of course, those that enforce privacy rules at a state level and state attorney generals, they too, might be able to take action even in the absence of some of these other regulations falling into place. Up until now, what we've covered is HHS's implementation of the Cures Act. So we're just going to shift gears briefly to what CMS has done in this space. So not wanting to be left out of the fun, CMS issued a companion rule using various existing regulatory authorities to push data sharing policies for certain types of health plans and hospitals. The CMS Interoperability and Patient Access Rule could itself be the topic of an hour-long webinar, so I'm just going to hit on a couple of highlights. Highlight number one, the Patient Access API. So CMS is requiring that the health plans it regulates implement standards-based APIs that patients can tap into using apps on their phones or other devices to extract their healthcare data. And the content that's has to be available through these APIs includes adjudicated claims, encounter data, and clinical data. Second highlight, this is directly applicable to hospitals, psychiatric hospitals, and critical access hospitals. And this is an amendment to the Medicare conditions of participation. So there is a condition of participation if you're a hospital that governs medical records. What CMS has done is it has amended that condition of participation to add a new standard, a new electronic notification standard. And what that standard says is that if you are a hospital using an electronic medical record or other electronic system that conforms with the ONC standards for electronic notification, the hospital is going to have to demonstrate three things, essentially. They're going to have to demonstrate that their system sends notifications, including patient name, the name of the treating practitioner, and the sending institution name, to post-acute care providers, as well as other practitioners. So for instance, a patient's established primary care practitioner would be someone that would be entitled to receive an electronic notification. These notifications are triggered at the time someone is registered in a hospital emergency department or is admitted for inpatient services. It's also triggered when a patient is discharged or transferred to the hospital. And these are going to be enforced by CMS only. They will, because they're conditions of participation, they're going to be enforced through the survey and certification process. So the surveyors that come to the hospital are going to be looking at a hospital's processes. They're going to be looking at their technology to ensure that the providers have the process in place to, make a reasonable effort to get these notifications out when they're supposed to go out to the appropriate recipients. Failure to meet Medicare conditions of participation can result in termination from the Medicare program. This is a very harsh penalty, but CMS has assured providers in the final rule that it intends to treat violations of this new standard as a standard level violation, not a condition level violation, meaning it should not trigger termination from the Medicare program. So we'll take just a few more minutes to try to pull together everything we've spoken about so far. I'll start just pointing out a few key dates to keep in mind. The ONC rule has become effective. It was effective 60 days after it was published, but ONC did delay the compliance dates until 6 months after publication. And we understand that ONC is intending to extend those dates out even further in light of the current public health emergency. For the CMS regulations, many aspects of these rules also have a delayed effective date or a delayed compliance date. For the patient access API, which applies to health plans, those requirements are going to go into effect January 1 of next year. CMS said it is going to start publicly reporting on hospitals that violate information blocking or fail to attest that they don't engage in information blocking. They plan to use attestation data from 2019 and intend to post that information. They said late 2020. We'll see if that deadline gets pushed back further in light of the pandemic. And then the admission, discharge, and transfer event notification, COP, that is not going to be effective until May of next year.
That was really helpful. Now let's turn to some practical tips for avoiding compliance pitfalls. The first one I would note is that it's really important to review your contracting terms. The information blocking rule may have a ripple effect through a range of provider agreements. For starters, it will be important to review existing vendor agreements, data sharing agreements, and basically any data touching agreement that's relevant to EHI access, exchange, and use, and also to upgrade and update existing agreement templates. Indeed, ONC clarified for us in the preamble that contracts and agreements can interfere with the access, exchange, and use of EHI through terms besides those that specify unreasonable fees and commercially unreasonable licensing terms. Business associate agreements, for example, that were put in place under HIPAA could potentially violate the information blocking rule. ONC noted in preamble that while the information blocking provision does not require actors to violate HIPAA-compliant business associate agreements, a business associate agreement or its associated service level agreements must not be used in a discriminatory manner by an actor to forbid or limit disclosures that otherwise would be permitted by the HIPAA privacy rule. Now, given the emphasis on the fact that some uses and disclosures permitted by HIPAA may be required under the information blocking rule, it seems questionable whether some covered entity-driven business associate agreement terms restricting a business associate's ability, for example, to de-identify and use, disclose, and in many cases monetize covered entity data, for instance, would survive scrutiny under the information blocking rule. ONC also warns that a BAA entered into by one or more actors that permits access, exchange, or use of EHI by certain healthcare providers for treatment should generally not prohibit or limit the access, exchange, or use of the EHI for treatment by other healthcare providers and patients. So there's really a lot here, and a lot of agreements are going to need a pretty hardy review. Keep in mind that the information blocking rule may also provide new protection for providers that have been struggling in unbalanced vendor relationships, and the new rule could afford providers new leverage in contract negotiations. So there really is a whole dynamic to consider here. Overall, providers are going to need to review their contracts through the lens of the information blocking rule, and through this exercise, they should expect to find both risks that need to be addressed and also opportunities that are waiting to be seized. And similarly, as Kelly is going to explain, policies and procedures relating to data access, exchange, and use that are already in place will need to be reevaluated, and some new policies will certainly be needed. Kelly, do you want to take it away?
Yes, and absolutely. The policies and procedures that are currently in place governing how information is used and especially disclosed to outside parties that request it are going to need to be reviewed. And in particular, if your organization has policies that have the effect of restricting use, access, or exchange of electronic health information, you're going to want to make sure that those policies are grounded in a reasonable interpretation of the law, because the entire reason providers are mixed up in the information blocking regime is because there was a sentiment that providers were misusing HIPAA in ways to capture referrals and maintain their market share. So be especially careful for policies that restrict access to only certain types of requesters. For instance, if there are policies that restrict access to competitors within the community, but other parties would have access to the information, that would be a potential yellow flag that you would want to dig down a little bit deeper on. And then the third tip is to create a framework for responding to requests. It's possible that as a result of these regulations, new requests are going to be coming in the door. So as an organization, you'll certainly want to have a framework for how those requests are going to be analyzed and dealt with. It probably makes sense to game out some hypothetical fact patterns, just so there's a shared understanding of how requests are going to be dealt with. Finally, just a few other things to think about. We've talked about how to mitigate some of your compliance risks. From an operations standpoint, you might want to be thinking not only how can our organization meet the regulatory obligations, but how can we do so in a way that creates value, value to patients, value to the community. Also, your organization is likely also going to be a requester. You will get requests for data, but you are also going to potentially have access to data sources that might not have been available before. So you might want to be thinking about what the organization's data needs are and how the new rules can be leveraged to advance objectives. And then on the government relations side, as we talked about, things are still changing. Compliance dates are getting moved back. There's going to be an evolution in the data sets that are going to fall within the definition of electronic health information. There's going to be additional policymaking and rulemaking in this area. So monitoring the developments is going to be important, but also flagging instances where it makes sense to engage in those policymaking processes. At a legislative level, there is activity around privacy. We have a patchwork of privacy rules. There's a recognition that once patient health information goes to a third-party application, that privacy protection from HIPAA goes away. And there's a desire among many in Congress to try to close that gap and come up with some privacy protections that will apply beyond HIPAA. So that's another area where engagement might be warranted. All right, that concludes our presentation today. Joellen, Daniel, and I are happy that you joined us for this, and we hope you found this presentation useful. You have our contact information. You should feel free to reach out to us if you have questions about anything that we've discussed today. for questions that came in through the chat function. We will do our best to respond to those in a timely fashion.